Welcome, everyone, to our latest episode of Legal Lunch Byte. My name is Jonathan Bench. I'm in Salt Lake City, Utah. I am joined today by my new colleague, Karen Albence, and she is in California. Karen, this is really, other than the few minutes that we spent before we went live, this is really our first conversation. We work in different practice areas, and I'm always interested to learn from other attorneys, because to me, the litigation process is always a little bit scary and unknown. But when I'm drafting contracts, I still have to think about where we're going to be fighting over things and what kind of law we'll be using when we're fighting. So can you please introduce yourself to our audience, and then we'll jump in.
Sure. My name is Karen Albence, and again, I live in California, Southern California. Right now, I'm located in San Diego, but I practice in pretty much any city in California. So it's a pretty big state. I've had multiple pending cases ranging from Los Angeles, Riverside, all the way to NorCal. So I've had a lot of experience with litigation cases, in fact, over 18 years. Business litigation, a little bit on the newer side within the last 5 years, but I've had a lot of wide, vast experience in litigation in general.
Excellent. So we want to focus a little bit on COVID and what COVID did to the litigation process. I know that for a while, everything shut down, and then courts started warming up to the idea of doing more remote hearings. So can you describe that process?
Sure. Before COVID, it was pretty common that most hearings, depositions, trials took place in person. In very few kind of unique situations, the courts would allow a deponent to testify remotely. Depositions may take place remotely, and trial was definitely taken in person. But after COVID occurred, many of the procedures in the state of California changed. There was a lot of concerns regarding health issues. It was kind of, very unknown at the time. And so the court system actually shut down for a period of time. I believe it might have been about a month or so, depending on which jurisdiction you're in. There was a complete shutdown. And it came about from an order that came from the governor, who obviously did a wide state shutdown of not just the court system, but pretty much of all the businesses. But, there's a lot of cases existing in the California courts. So some of the jurisdictions had to figure out different ways how to open up. And they did so, but they did it in a modified fashion. Civil cases, they pretty much put all the cases on hold, and they still move forward on a limited basis with the criminal cases, because obviously there were issues with due process rights of the individuals. And so thereby they just put those cases which are civil cases kind of on the back burner until they could figure out a new system and how to move forward with all the number of cases each jurisdiction had to handle. So
That's so interesting. So typically when you're in trial, were you using technology before? I mean, is it common to put exhibits up for the jury to see or for the witnesses to see? I've only sat in on really a handful in my career, and that was back when I was a law student.
Yes. In trial, it's very common to provide exhibits within the courtroom. And it can be done different methods, but the most common is obviously through your computer where your exhibits are being held. You can easily put it up on a screen that's set up in the courtroom. However, with remote testimony, and recently, very, very unusual, an entire trial we completed remotely, you are very dependent on very good programs that you had to use in order to get those exhibits up on your screen, and had to learn how to move quickly with those exhibits. It was a very unusual, unique situation, but it was a learning experience as well, because this may be the trend moving forward. So to have that understanding experience now is probably a good benefit, but there's also downsides to that. In person, having a trial in person, having depositions in person, and having even hearings in person, you gain the benefit of communication by body language, being able to read someone more clearly, seeing facial expressions more clearly, and you lose a lot of that with the changes in trends of remote appearances, whether it's by trial, deposition, or even in hearings, you lose that. And that's a great benefit that you would need generally in litigation. So it's not all about what someone says, it's how they say it, and it's also their body language.
Right. And so can you contrast the difference between doing a bench trial and a jury trial? I have to imagine that it's different. I mean, just from a practitioner standpoint, it's got to be different presenting your case to a judge versus a jury. And then adding the technology layer on top of that now, do you feel like this is me projecting myself into your space, but I feel like it would be a little bit easier because you only have to focus on the judge. So the technology wouldn't be as big of a hurdle. Whereas if you're trying to focus on all the jurors as as you're providing arguments or as your opposing counsel is providing arguments and trying to read all those signals simultaneously, which is got to be harder to do on a screen as opposed to being in person.
Yeah, that's correct. The trial that we just completed recently was actually a bench trial. I believe because it was a bench trial, the parties were able to agree to remote appearances, attendance, and completion of the trial remotely. If it was a jury trial, that would not be an option. I don't believe it would be an option. It would be too difficult to try to read the jurors and then also get evidence up on the screen quickly enough. And also, whether it's in person or remotely, you can lose people's attention. And you generally find out when you're losing their attention when you're in front of them in person. And you don't gain that benefit if you're remote, because obviously it's much more difficult to look at an entire screen of 12 individuals plus 2 alternates plus the judge plus the witness. So it becomes an issue where you lose that benefit. So I would say I don't even know of anybody thus far who actually has completed a jury trial remotely. I believe the counsels and the parties probably would not agree to that. With a bench trial, it's much different. You've got, like you said, you just have one judge. They're listening to evidence. They're more lenient about timeframes and producing evidence and documents on a screen. They understand some of the difficulties with new technology. With the jury, I don't think they're as probably open to there being a long delay in putting up records and producing witnesses. And again, you can lose the attention span of a juror much more quickly than you can lose one from a judge. So, and again, I have not heard of any attorney thus far, my own experience and from my contacts, who's actually handled a jury trial remotely. I don't believe they would agree to do that. What's interesting is after COVID, and when I say after, I meant after the stay was lifted relating to the court system, I actually did have a trial in San Diego County that took place approximately about 2 years after the restrictions to stay at home. But the new restrictions that were put, though, however, was that the jurors were allowed to wear masks during the trial, which again, with that being said, even though it was in person, you still lose that ability to be able to read facial expressions and understand what the juror is thinking. And so thereby you actually lose that. So we actually opted for purchasing ourselves shields, face shields, which were clear. And we told the jurors that they could wear those face shields, and that whereby we could still see their facial expressions during the trial. So it's kind of a trial and error going through this whole process. No, I didn't mean to make that kind of joke, trial and error, but meaning you actually had to kind of go with what was happening, the newer changes, and then realizing that you had to adjust. And there's different ways to adjust, but it's been a learning curve for everybody, not just the court system and not just for the attorneys, but also for the judges, and also for the witnesses and for the parties themselves.
Right. And how have clients adjusted to this? You and I were talking earlier about the difference between having clients in Europe and clients in the US. Do you feel like your clients kind of just rolled with it when you said this is the new normal for how we have to deal with this situation, or were they pushing you to try to do, I'm thinking about the expense of the face shields, for instance, face shields, maybe you've got other things. Their clients generally just understand, we need to move forward, and it's better than pushing the trial off until everything went back to normal.
I believe so, just because the trials have all been pushed so many times due to those type of restrictions that the cost of something like face shields seemed very low, considering what the clients were losing in time by not having a trial take place right now. So I would have to say all of the clients have been very open and accommodating to the situation. And of course, all the clients are living in the same society that we are. I mean, they know this from personal experience. They have a business that's been shut down for a while. Many people lost their jobs. A lot of people had these new ways of living where you're working from home and they have children and they're having to figure out how to deal with the court systems, and then also dealing with school systems, and also, this new life out, working from home remotely and having children at home constantly. So I don't think it was something unusual and unique for any of the clients or something unknown to them, because they were already living it. But when you provided the options to many of the clients saying, hey, we've got to make different accommodations now, we can move for your trial right now, but we're going to have to do, A, B, and C a little bit differently, which we would not have to do before COVID. Or do you want us to wait and see what happens in several months with these type of restrictions? I would have to say the majority of clients say, let's move forward. But there were times when it wasn't our choice. The court just simply said, we cannot try your case right now. We don't have a courtroom available for you. And there were some other issues too that I found out that I was not made aware of until my in-person trial that occurred possibly about 6 or 7 months ago, that if any one of the staff members in the courtroom came down with something as simple as a cough, they were out for approximately 7 days. And so they obviously didn't want that to happen to the judge, but if it happened to the bailiff or the clerk of the court, they were out and they put in a replacement. And they had some real concerns about that spreading. So even today's date, there are a lot of precautions still in place because the court system, they just don't want, somebody to bring in something. And it doesn't have to be COVID necessarily. It could just be any cold or sickness, but they're very concerned because of the close proximity of all the people who have to attend trial within the courtroom, that it could spread pretty fast. So, so there's been new changes everywhere. It has affected everybody. And then maybe that's sort of the bright line situation here, or the silver lining in this whole situation, is that everybody is going through the same situation together, whether it's through the court system or through their personal lives or through their jobs. So everybody's been very cooperative and understanding of the situation.
So I've got two questions for you about efficiency now. Do you feel like judges have embraced this? I feel like if I were a judge, rather than having the parties come in and waiting for people to arrive, that if I can just sit at my desk and work and choose to operate most of the trial or all the trial remotely, that I would certainly embrace that if it were up to me. But that's just my personality. Do you feel like the judges are really happy about kind of streamlining some of these processes?
Yes and no. And it really depends on the jurisdiction, and it depends on the judge. And I actually wrote a blog post about just recently about, making sure you monitor not just a broad general sense of the rules of civil procedure, which obviously could change on a yearly basis based on new trends, and also things like stay-at-home orders and then variations to the codes. But you also have to look at the local rules for each county where your case is sitting, because they have specific rules on how they want to handle these matters moving forward. Then on top of that, you have each judge has their own specific courtroom rules in which how they want you to handle that. And I would look at it as like fishing. The CCP codes, which general or for everybody to follow, it's like a wide net. This is what you're supposed to be doing. Then I would look at it as the county rules, the local county rules, is a smaller net. But that smaller net is what trumps the larger net. And then at the very last, you've got the judge's own specific courtroom rules, which is the smallest net, but that one trumps all the other nets. And they tell you how they want you to proceed. And so it depends on the jurisdiction in the court. Like, for instance, there are some jurisdictions in California in which they stated, we do not want you appearing in person for certain type of hearings. If you have a law motion hearing, which could adjudicate some of the claims in your case, you should be there in person. But for the other hearings relating to, let's say, setting of dates, or there's an OSC called order show cause, we want an explanation from counsel relating to some outstanding issue in the case, do not be here in person. It can be done remotely, or we're just going to send out an order from your papers. Now, let's talk about some other jurisdictions, some changes. They had an opposite problem where now you had too many attorneys who were so used to remote attendance that they're overbooking all their hearings for very minor discovery issues, which they would never have done before the days of COVID. Because before COVID, you would have to hop in your car, drive over to that courthouse, park, obviously present your issues or case to the court after your papers were done. And those extra steps that you had to do made those attorneys assess those cases or that issue in that case, whether it was valuable for them to go forth before the judge and bring up this whole issue. Because of remote hearings, attorneys were overbooking the whole system with all of these minor issues that could easily be resolved on its own, or two, should not have come before the court. So they're now judges are saying, if you set up these type of hearings, you must attend in person unless you get permission from the judge before the hearing that you may attend remotely for specific reasons, which could range from like you're truly sick, or you're from out of state, or you're not within the jurisdiction. So, we're now seeing another trend going the opposite direction. But it's everybody's in the same situation, so you just have to go with the changes and then understand why, and then you have to adapt. And everybody's had to learn how to adapt. So
that's great. Well, we're at time, and you actually answered my second question, which was who gets to decide how much of this happens remotely and how much in person. So I really appreciate you taking the time to sit down with me today. It's been fun to get to know you better, and definitely we'll catch up again soon.
Thank you, Jonathan. Thank you.
And for everyone out there who's watching, next week we will be talking about blockchain developments in Brazil with my friend Julia Pazos. So if you're interested in what's going on in South America around blockchain, she's one of the foremost experts in Brazil on blockchain and IP. Thanks, everyone.
Thank you.